Well, a surrogacy dispute involving abortion and parental rights now playing out in a Texas court. The surrogate wanted to continue the pregnancy after the intended parents chose to terminate the pregnancy following a diagnosis of a severe heart defect. The baby has now been born and is getting medical care, but the legal fight over who has parental rights, that's just starting. Now the Trump administration is also stepping into the case, with HHS warning 2 Dallas hospitals they cannot withhold medical treatment based on the baby's disability. Live now to Rachel Rebouché, who's a professor of law at the University of Texas School of Law. Rachel, the Texas court has found the intended parents and the legal parents. So where does the surrogacy custody claim stand right now?
Well, at the moment, the surrogate is arguing that the contract that she signed with the intended parent should be set aside, that a court should find it void. And if the contract doesn't exist, her argument is that she is the birth parent. And under Texas law, if there's not a judgment from another state or a validated gestational agreement, the birth parent is presumed to be the parent. So I think that's the crux of her argument, that the contract should have never existed as written.
Okay, so contract law is very solid here in the United States, and we know that these surrogacy contracts often address what happens if there's a fetal abnormality, if it's discovered during the gestational process. So how do courts handle a situation where the contract calls for one decision, but the surrogate says she doesn't agree?
Well, a court would never force a surrogate to make a decision against her will. There's no court in this country that would order a surrogate to end a pregnancy because a contract said so. That would be unconstitutional. But you're right, these provisions exist in all contracts. They try to bring intended parents and surrogates together before conception to agree on what they would do if certain diagnoses or conditions manifest during the pregnancy. Here is the rare case where the parties deeply disagree and a conflict ensued. But a court would not order anyone to do something against their will, against their medical wishes.
So now enter the state of Texas reportedly monitoring these medical decisions being made for this baby. What does that mean legally, and how much authority does the state of Texas actually have over the parents' medical decisions?
The state of Texas has some power over these intended parents. The court in Texas has issued a temporary restraining order instructing the hospital, all relevant parties, to act with the best interest of the child in mind, and keeping the parents from leaving with the child until a hearing on August 25th, and essentially, vetting that the decisions that these intended parents make are in the best interest of the child, help sustain the life of the child. So the state of Texas is heavily involved in this case and will continue to be involved until the court decides that the intended parents can leave the state with the newborn.
Rachel Rebouché, thank you so much for that analysis. Good to talk to
Thank
you.
you.